Garcia, we were calling you before. Michael Nowak, page 27M.
Good morning, Honor. Nicole Garcia on behalf of the state of Florida. I apologize, I had a couple of calendars this morning.
It's fine. Let me get to the page, 27M. Okay. Who is counsel for Mr. Nowak?
David Terrace on behalf of Michael Nowak.
Okay.
And my partner, Betty Ross, is also present on behalf of Mr. Nowak, and Mr. Nowak is present via Zoom as well.
Morning, Judge.
All right. What is this on for? It says motion to increase bond.
Yes, Judge, I did not file a motion. So what happened in this case, Your Honor, is that this is a media case. He was arrested for punishable by life crimes. He should have been held no bond. However, this is one of those charges where the PBL comes in at the very end of the charge, and I think the clerk's office made an error, allowed him to bond out prior to seeing a bond appearance, or prior to going to bond hearing. Somehow I think he was given standard bond of $21,000, $10,000 on count 1 and count 2, and then $1,000 on count 3, Judge. My issue, Judge, is that there's no stay away order on the case yet. That's why Your Honor asked the defendant to be present. I also am very concerned that the defendant has been essentially terrorizing the victim. I mean, the victim's 14 years old, and there's been a lot of...
Since the arrest?
Since the arrest, Judge. He's been very communicative on, he's been very vocal on social media, on, there's been videos of the victim drugged by this defendant leaked online. Your Honor, on this case, we do have DNA showing that the defendant's sperm was on the victim's clothing.
Your Honor, may I ask why any of this is appropriate, considering no motion has been filed?
Yeah, that's the thing. I don't like being ambushed with all of this. This is...
Nor do I, Your Honor. This is entirely inappropriate.
If, in fact, the state was seeking a motion for pretrial detention, they should have done it. I mean,
well,
now,
Judge,
as far as the stay-away order is concerned, I can certainly do that. But I just can't go ahead with allegations from the state without giving notice to the defense. I mean, certainly I would hear it, but I can't do this in a vacuum like this. So the only thing that I know that this was reset for, which was advised to me the last time, is that the stay-away order was not properly presented, and I'm ready and able to do that at this time.
Judge, you are the first appearance, Judge, regarding the information that was filed, Judge. He was charged with a total of 6 counts, Judge, and they're different. They're all different from the charges, except for one.
Again, Your Honor, excuse me, I have to interrupt. This is entirely...
Hold on. Mr. Terrace, hold on. Let her finish. Just let her finish. I'll allow you to make your argument. Go ahead.
Thank you, Your Honor. He has been charged with 6 counts. One of them is the same, but there's 5 additional counts, Your Honor. Your Honor does have to set bond on those counts. And then the stay-away order has to be set. I will be filing a motion to increase bond. And I understand that Your Honor does not want to be ambushed. I will file that at a later time, but I did want to put the court on notice that with regards to the other bond amounts that need to be set, Judge.
All right.
So we definitely have to address bond. Okay.
Now, did you have a response, Mr. Terrace, and then I will deal with the information?
Yes, Your Honor. We don't. There is no motion pending before the court. The state. No one, our side certainly did not ask for a schedule bond. That was something that the state of Florida decided to place on this case. Those charges were higher charges, and they were downfiled. Doesn't matter that there was more charges that were listed on the information. These are downfiled charges. Mr. Nowak is out on constitutional bond. There's no motion pending before this court, and there's no need for Ms. Garcia to just ambush us with additional information that she feels the court and the media in her speak should hear. So we are entirely prepared to address a motion that's before us. Not another word needs to be said regarding a motion that's not pending before this court. We do and are prepared to address the no contact situation today.
Okay. Now, first things first. First thing I have is an information that's been given to me by the clerk that was filed on September 14th, which was 3 days ago. And again, I have many cases on my calendar. Has this defendant been arraigned on this information?
He has, Your Honor.
He has, Judge.
He has. Okay, so he has been arraigned, and I am looking at, there are a total of 6 counts. I, at this point, do not see that there are any non-bondable offenses. And there appears to be a second-degree felony for count 1, second-degree felony count 2, 3 is also second-degree, 4 second-degree, 5 is a first-degree misdemeanor, and 6 is a third-degree felony. So have all of the bonds been addressed at the time of the arraignment?
No, Judge.
No, Your Honor.
Okay, well, that's what we need to do as far as that is concerned. And I will, what was he out on previously? Let's just start with that.
He was out on count 1 and count 2 for $10,000 each. And then count 3 on the information was a misdemeanor, so that was $1,000. So right now he has a total of $21,000 bond.
Okay, so 1 and 2. So what was added in the information?
So the counts 1 through 4 are all second degree felonies. Those were not on the information on the
Were not
arrest.
originally charged?
Correct. Also, Judge, count 6 is interference of custody. That one also was not charged. Count 5 was charged as count number 3 on the arrest form. So that one should stay $1,000.
So then what was the original 10,000? If you're saying that 1 through 4 was not charged, and then 6 was not charged, then what was the original charges where he got the two $10,000 and then $1,000?
So the original charges was count 1 was engaging in sexual activity with a child and familiar custodial authority. That was actually a PBL, but that charge, when it's input into the arrest form, it looks like an F1. So on that count, he was given $10,000. Then on count 2, it's sexual battery of a victim 12 to 17 years of age. That's an F1. That was another $10,000 bond. And then count 3 is count 5 on the information.
Okay. All right. So as it relates to the new information, the court is going to, on count 1, the defendant will be given a bond of $10,000. On count 2, defendant will be given a bond of $10,000. On count 3, defendant will be given a bond of $10,000. On count 4, defendant will be given a bond of $10,000. On count 5, that will be a $1,000. And count 6 will be $5,000 bond. All right, does corrections have that? Well, all right, clerks have that as well?
Yeah, I have it, Judge.
Okay. So he is going to need to post those additional amounts. If it was $21,000 originally, it's now going to be
46.
$46,000 additional bond. That's as to that issue. Anything further on that issue, and then we're going to get to the stay away order.
So, Judge, I do think it's important to note that he is a California resident. So I would ask that Your Honor consider that when setting the bonds. Are these standard bonds, Judge?
I do not know what is considered a standard bond on these, but these are the bonds that the court's going to be giving.
Okay. So, no, Judge, I'll be filing a motion to increase bond due to the facts of the case. The other, in addition to the bond, Judge, it's just a stay away order I think that we need to address today.
Understood. All right, anything further from the defense as to the bonds for right now?
Your Honor, I don't see that the state has laid any grounds for why the bond amount should be increased. We
Well,
believe
we're not
that
there yet. We're not there yet. There's no discussion right now. That's not what's before the court. The court just is setting bonds on the new counts.
these counts are downfiled. I just want to make that clear from the record, even though there's more of them.
Understood.
So but we would object to the entire bond amount increasing, considering these are downfiled charges.
Okay, the objection is noted.
Other than that, no, Your Honor.
All right, as it relates to the stay away order, okay, so apparently these are minors. If I can have the defendant sworn.
Mr. Nowak, can you unmute yourself?
Raise your right hand. Do you swear affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, sir, you can put your arm down. Can you tell me your full name and your date of birth?
Michael Eugene Note Jr., born August 10th, 1983.
All right, thank you, sir. All right, so you are currently charged under case F21 14438 with several counts involving a minor victim. And the minor victim is identified as T like Thomas, S like Sam. Do you know who that is? All right.
Yes.
Sir, you are ordered that you can have no contact with TS. And when I say no contact, that means no direct contact or indirect contact. Indirect contact includes you cannot communicate with this individual via social media, you cannot call, you cannot text, you cannot reach out to this individual or in some way attempt to communicate through a third person. Do you understand that, sir? All right, now,
Yes, I do.
I will just advise you and admonish you, this means what it says. I do not know whether or not you were given any type of a stay-away order, but as of right now, this stay-away order is in effect, in that if you violate any terms of this stay-away order, that may be grounds for your bond status, your pretrial release status to be revoked, and you will be immediately taken into custody. Do you understand that, sir? Okay,
Yes, I
anything
do.
further on that issue from the state?
No, Your Honor.
Anything further from that issue from the defense?
No, Your Honor.
All right, that is all that the court has before me. Are we done? Ms. Garcia?
I believe so, Judge. I just want the defendant to be aware that he should not be posting any social media posts or anything about this case, about the victim in this case. I know that there was a video of the victim leaked on social media. I'm concerned about the victim's, well-being regarding this case. So I just want to make sure the defendant's well aware that if that happens, we will be filing the appropriate motions to avoid that from happening.
All right, well, just
May I
so
respond,
it's
Judge?
clear, just so it's clear, I just want both sides to know, allegations are allegations. I certainly will respond to some type of evidence shown to the court that the defendant has somehow violated the court's order. Now, let me hear from the defense.
Judge, I just want to make clear for the record as well that this arrest, Mr. Nowak has been compliant and has known about this investigation for far before his arrest, has come down and voluntarily submitted 2 warrants along the way because he has nothing to hide. Any allegations that the state is making about their fear that he might have been tampering or attempting to scare the alleged victim via social media, there's no order saying that he is not allowed to use social media. And I also would like to make clear that it took the state till 4:56 p.m. on the night before the arraignment to file an information here, and a reduced one. If they were so scared, they had ample opportunity to file a motion in the meanwhile, and they failed to do so. So I don't believe that Your Honor has taken into consideration any of the arguments that they've put forth regarding why they believe bond should be increased, because that's inappropriate.
We're not there. I'm not even entertaining it. So let's not even. I don't even want to hear anything about it because nothing's before me as to an increase.
Well, Your Honor has the ability to set the additional counts at ROR.
Well, I'm not. I can tell you I'm not. Based upon the only thing I have in front of me is an information. That's what I've decided as far as the bond is concerned. That's it. Nothing more, nothing less.
Well, we would object to Your Honor taking into consideration any of the statements made by Ms. Garcia in reaching that determination.
Okay. Now, however, I do need to just advise Mr. Nowak, based upon some of the arguments. I don't know what is out there that has been posted, but I will advise Mr. Nowak that if in fact there is evidence shown to the court that you have somehow been responsible for submitting some type of social media involving this victim, you may have a First Amendment right, but it is limited. And if the state can show that this was done with some type of intent to either harass or intimidate a witness, that's serious. So just keep that in mind. You certainly have a First Amendment right, but if you do something that in somehow is intended to intimidate this witness, then the court will listen to what the allegations are and what evidence the state has presented. I think that can be the last word on this matter. I have a December 3rd report date. What is that on for?
I believe that was just for the status, Your Honor, case disposition, regular.
Okay, perfect. All right, as of right now, that's the next date that we have on this case, okay? Thank you, everyone.
Thank you so much, Judge.
Okay.
Welcome to Breakdown Friday. Joseph Ward, Professor Carl Tone Jones, Patrick Irvin. We are here breaking down this Brother Polight situation. And how did we get here? Just going over everything that comes with Brother Polight and seeing the impact that it has had on our community, whether good or bad. So this was clipped from a bond hearing. But within the bond hearing, we did hear the prosecutor talk about the evidence, the physical evidence that they had, the DNA evidence that they had from him, and we all have seen plenty of videos and read information about this case, about Brother Polight and his SA allegations against the daughter of the young lady he was dating at the time. The young lady, from my understanding, the daughter is a 14-year-old young girl at the time, and Brother Polight was able to get the young lady by herself, according to the allegations, and introduced alcohol into the situation, used that, and the essay happened, and the mother called the police and everything we have from here. I've even heard a audio from the mother speaking out about what has happened and the impact. And of course, we're not investigators, and we don't have all the evidence and all of the information, but we do have information. And just want to dive deep into it, but dive deep into Brother Polight as a whole. Because how did we get here? So PC, start with you. I mean, you know more about the brother than we do. I'm sure you out there a little more than we is. So you done seen the brother. I'm sure you bump shoulders with the brother. So, like, first of all, before we get into him as a whole, what are your thoughts about this case, this video we just saw, just everything that's surrounding this case?
Well, first we have to use the word alleged, that's reliable.
Allegations. Yeah. Alleged allegations.
There's no way around it. This is horrific. Because I remember when Tasha K first broke the story, and the shit sounds so crazy. I said, well, hold on, let's wait until all the information comes out, before, because she was already in trouble with the Cardi B situation for falsifying or making false statements. But the more that came out, the more and more came out about this. This is sick. To have a grown man parading a 14-year-old, allegedly parading a 14-year-old around town. I believe this happened in Miami. So to have her parading her around town, and you going into these abandoned buildings and things of that nature, the girl's mother had no awareness of where her daughter was all this time, and her herself, I believe she was being courted as a wife for Polight at the time. So, I mean, this is just like, this is cultish type weird. You know what I'm saying? The way that it all unfolded, just based on what we know. There's no defending Polight for any of this, because you put yourself in a bad situation to be just alone with a 14-year-old girl throughout the wee hours of the night. And, for the evidence of, the fact that they found his fluids on her clothing.
Mm-hmm.
So there's just no way around it. You know what I'm saying? This is sick. And you know, I hope, like, well, first and foremost, that the fact that there's such a low bond really really speaks about how much this system cares about black girls. Because you know, if she was a white little girl, I'm pretty sure he wouldn't have made bond, let alone has such a low bond to deal with. You know, the system is not a friend of black people, definitely not a friend of black children. To sit back and just listen to that hearing, and then you know, and I'm a all right. So I'm gonna get into how I know of Polight, because I don't know the brother. All
Mm-hmm.
right, we need to use the word brother when we talk about him at this point. Um, I met Polight in 2013 as security at Black and Nobel at the Black and Nobel bookstore, because um, my good brother Hakeem Hopkins, who ran the bookstore, he Polight would come down a lot. So that's how I met Polight. Um, and I would listen to him talk about status correction and all this other stuff, and being a sovereign citizen, and you know, maritime laws and things of that nature. Which,
But we're gonna get to,
okay,
we get into that.
So, in fact, if you go back to some of Black and Nobel's, if you go back to 2013, there was a debate between Polight and Tazariot of the ISPUK, I believe is
Yeah.
second
I
of
know
the
IU whatever.
of the Hebrew Israelites. I was there. I literally broke up a fight between Polight and another brother that was there, who was emceeing the program that night. So that's pretty much the extent that I know Polight. Other than that, I want to make this clear. I have no relations with that man.
Yeah,
None.
I didn't. Yeah, to make it clear, I'm not saying I didn't. The way I
Right.
set it up, I ain't saying like they homeboys, but I just know he knows
Yeah,
more about Polight than
yeah.
we do.
So I just wanted to make that point clear, because um, you're right. I have been out there, and I know, or I've been I've been in a lot of circles where these people live, these people be. So I mean, but I just wanted to be clear, because I don't want any affiliations with that man or any of this shit that's going on right now.
Mhm.
Um, you know,
This, yeah,
can't can't defend any. First and foremost, I love children. I love black children. I'm actually wearing a shirt right now. Um, the young man named Gerald Sack, right? This young man, his mother was a student in my class. This young man was murdered on his porch while his father was trying to get him in the house, because some young hoods pulled up on his porch. So they created the Gerald Say Defenders Foundation. So basically, this is a program about protecting our children in our community. So, and that's pretty much the biggest aspect of anything I've done in this place, in this space. So when I hear about somebody harming a child, it actually feels personal. You know what I'm saying? Because you know, children children need to be defended and protected. And as black men, our job, our primal job, our primary job is to make sure that children are protected. You know, women and children, if we can get on page with the women, but the children are they're innocent in this situation. And I feel like when you violate a child's innocence, the punishment needs to match the crime. So I'm just gonna leave it at that. Leave it at that for now.
this is not a good situation. It's not a good look. It's not a good legacy. It's not good energy. None of this is good. It's another blow to the conscious community. It's another blow to the guess you could say the educators, the scholars. Like Pat always talking about how people have to pay the ones who come after have to pay the tax for the bull that the people before them did. And this is going to be another thing that a lot of good people are going to have to pay taxes for, because a situation like this exists surrounding somebody who have had such influence, especially on the conscious community. And from my understanding, when I was doing as much research as possible for this and see how much information was out there, I've watched a couple of different videos, and I've heard people talking about there are men who are, trying to defend him and his actions and everything. And of course, we don't have the evidence with us to present, but we do know the evidence that has been presented. And we just saw this. We just saw the clip, and you see the prosecutor talking about the charges and the evidence that they have. So that's why I wanted to show this clip, because we're not making that up. That comes from the prosecutors. And so now, of course, everything has to play itself out. But the fact that all of this is happening is bad news, and especially with somebody like Polight, who I'm gonna be honest, I never really listened to Polight. We've had these conversations for years. Pat and I, we've had these conversations for years. I never gravitated toward him, his talking points, his movement, anything like that. Intuition tell me no, I listen to my intuition. But that aside, that has nothing to do with how I'm looking at this situation, because I want to make sure that we look at this situation not from a feeling-based standpoint, but from a realistic and a evidence-based and academic standpoint. Because how this plays out affects the community. What has happened so far affects the community, whether positively or negatively. And as people who talk about building up the communities, people who talking about being conscious, being awakened, being aware, knowing what's going on, we can't have anybody in the community trying to harbor somebody who their character is questionable right now, especially because of the evidence that the law have. So, Pat, what's your thoughts on this, man?
PC, you were finna say
Oh,
something?
my bad.
No. Well, no. We'll get into that. Because Judge mentioned something, about how, Polight was, he was a polarizing figure for a long time ago, and I was going to get into that. But no. Go ahead, bro.
I think people, this is another one of those, when we're talking about it from the standpoint of what you guys were just mentioning about how people are, circling the wagons and stuff. This is another one of those goalpost moving situations.
Mm-hmm.
Because first off, let's address this before anybody else tries to undercut anything we say going forward. We understand what the lady was doing in terms of presenting information that was not needed nor helpful for what they were at court for in that moment.
Right. It was a bond hearing.
Right. It was a bond hearing. So we understand exactly what she was doing in terms of presenting this information to sway public opinion or to, do anything like that. That's not the issue. And for you to make that the issue is for you to show how little value you place in the children of the community. The fact of the matter is disturbing because she even has that evidence to use in that way. The fact that the state even has evidence where they can say we have this man's fluid on her clothing, that statement should not be able to be made.
Right.
Period.
Right.
Without it being a bold-faced, stone cold, plainly viewable lie. Now, again, we don't know if it's not a lie because all this is alleged. But what I will say is, for them to be presenting it the way that they're presenting it, with the veracity, the tenacity, like they've been strong on that.
Mm-hmm.
It's kind of hard for me to believe that they don't actually have it.
Right.
So this is not, for me, this is not about because I know when you start talking about Polight and all these other guys, you know, you start getting into, you know, we start talking about the sovereign citizen movement and all that. You start getting into word games. You know, everybody start playing Scrabble. So I just want to take that off the table, right off the board, because they'll undercut the argument by saying, yeah, but legally on Article 465 of Code 2468, according to the Geneva Convention of the aliens from Mars that came with Yakub, that wasn't even permissible. And you'd be like, first off, don't none of that even mean shit. But second off, it misses the entirety of the point. The point, and then you have the other argument of people that would say, well, yeah, but why did the mother give it? That's beyond the point too. Like, I get it. If you want to make that argument that the mother shouldn't have trusted a man to be alone with her baby, I'm not even gonna argue that with you. But that's not the issue at hand, because I'm a trustworthy person. I've been left alone with plenty of people, and I ain't never done nothing to nobody.